Okay, let's get started. Good evening, everybody.
Good evening.
So, let's get into our next chapter, which we'll talk about corporations, which is just going to be like a refresher on what we talked about last week, because this is going to be more about avoiding liability from a corporate standpoint. And so, we may have some Socrative questions at the end. Who knows? I may just skip out before those. But if you want to, you can join my Socrative room, Prof. Blackmore, and hit join. This is just going to be a breeze over from our last conversation when we talked about chapters 13 and 14. We talked about some forms of entities, sole proprietorship, partnerships, talked about partnerships, general partnerships, and limited partnerships, the two types. Then we talked about limited liability partnerships. Then we talked about limited liability companies. Now here in chapter 15, we're going to talk about corporations. Okay? And then your book gives you a little blurb about corporate entities. And I want to, stop here so that everybody will know. Some of you like to, play corporate lawyer for your family businesses. I have a few in this class that people have let me know about. And so I just want to let you know each state has a specific law, often called the business corporation law, that covers such matters as the structure of the corporation, oversight of the activity of the corporation's managers, rights of the principals, in the case of the sale of assets or ownership interests, annual reporting requirements, and other issues that affect the internal rules of the business venture. So you may want to check that out in the event that you want to set up a corporation for the purpose that we talked about last week, and that is to avoid personal liability in the event that something happens and somebody wants to sue the company. They can't come after the personal assets of the person because of the way that the protection that a corporate entity provides to individuals. And so your book talks about the privately held versus the publicly held. Most of the corporations that we'll probably be dealing with in here, like I said, we have a lot of family-owned corporations in here. Those are going to be like privately held. It's not going to be like Google or something like that, where people out there selling stock and the company, that's what makes a company publicly held. When a company needs to raise capital, they'll go out there and sell stocks for the company to capitalize the business. And once that happens, then the company is a publicly held company. Now, our companies, like the lawn care company, that's probably not going to be publicly held. It's going to be a privately held company. And when you go out there and you decide you want to capitalize the business like Google or something like that, and they want to sell stock, then what they have to do is they have to do an initial public offering where they offer the stock at a certain opening price or whatever the case may be to capitalize the business. But we're mostly going to be dealing with privately held corporations. And then our book talks about formation. Okay. It's easy to set up a corporation. In any state, the only thing you need to do is file a document called Articles of Incorporation. And so we're going to look at what that looks like in California. Oops. Okay, so you go out here to this website out here. This is Alex Padilla, is the California Secretary of State. This is where you would file your Articles of Incorporation with the California or with any state's Secretary of State. There's going to be a corporation section. If I wanted to look up a company, find out whether that company, if something happens and I wanted to sue somebody, something happened at the business, somebody's business in here, I'm going to see if I can sue you personally. So the first thing I'm going to do is go out to the Secretary of State website and I'm going to look up your company. Let's say I want to see if Albanese, and you have to put corporation name, and then I hit search. And look, there it comes. But look, it's suspended. So this company is in a corporate status that is suspended. So really and truly, I might be able to sue Mr. Albanese personally. Okay? Now, when you go out here, you can look at the registration document, and here are the articles of incorporation. Now, before you decide that you want to go out there and file articles of incorporation, you want to go to what we have talked about in the prior slide, the business corporation statute for this particular state, and find out what I need to put into that document. And see here, this is a listing of everything in the business corporation statute for this state here. This is the corporations code for California. And then here are all of your, it tells you organization and bylaws, everything you need to do that. And down here gives you all of the information that will need to be in those articles of incorporation. Okay. And then I want to stop here on this particular slide because your book talks about how some corporations choose the state of Delaware as a state of incorporation. That is you want to keep that in mind when you are deciding whether or not you want to incorporate a business. There are some other reasons why people may do that, but many people do it so that they can have the status of being able to do that diversity jurisdiction in federal court and remove a case so that they're not within the purview of a state elected judge. So it just depends. These are liability points that people think about when they incorporate a business. When you're in in a state like California, it's a liberal state. You're going to have a lot of plaintiffs, lawyers, and the judges may be plaintiffs' judges. So you may want to get out of that situation and be able to remove that case to a federal court, a lifetime appointed judge that doesn't have political leanings. Yes, ma'am.
So if I want to start a business, I can incorporate in whatever state I want to incorporate in, regardless of where I'm running my business at?
Yeah. Yeah. Yes, you can incorporate, you can have a business here that has a headquarters in California. You can incorporate that business in the state of Delaware. Okay? And then this is the piece right here that is most important to me, the liability. The shareholders, directors, and officers of a corporation are insulated from personal liability in case the corporation runs up large debts or suffers some liability, i.e. a lawsuit. And now, when there is something shifty going on, there are a lot of people that just like to dodge being sued personally, so they'll incorporate a lot of entities and you don't know how to get to that particular person. And so sometimes you may need to do what is called pierce the corporate veil to sue that person individually. Say to the judge, hey, this person's hiding behind a whole lot of different corporations so that we can get, and then we can't follow the money and we can't sue him personally. So then you may need to move the court to pierce the corporate veil to sue that person in his personal capacity. And then I left this slide in here for Ms. Natalie, but she's not here today because she was asking a question about this in the last class, because sometimes, some of your business clientele may know about this and they know that they can't get to your personal assets, and so they may ask a person to do a personal guarantee so that they can get around that in the event that there is some type of capitalization problem or any type of liability. Yes, ma'am.
But
Yeah.
let's say I'm incorporated, and everywhere I go to get a loan, my landlord, and all the other creditors that I, tack on, if all of them make me give a personal guarantee, then doesn't that sort of like make it like mute to even start a corporation? Like,
I'm just saying nobody can make you do anything. So I would say don't do it.
oh, so you said like maybe find another bank or
Yeah.
another landlord that
Yeah.
may not. Okay.
Yeah, absolutely. But these are considerations that need to be kept in mind. Yeah, people need to be under the understanding that nobody can make you do anything. Be clear on that. And don't do it. Don't feel under duress to do things thinking that, that you have to do it. No, think twice in a business. And then this is just more information on reasons why people would want to, or reasons that courts would allow a person to pierce the corporate veil and sue somebody personally. Okay, so let's move into the bankruptcy portion, and I wanted to move through that quickly because we covered a lot of that last week when we talked about some of those other entities that provide insulation from personal liability, like the limited liability partnership and the limited liability company. Okay, so now we're going to move into the bankruptcy portion of it, and the book categorizes the unsecured versus the secured creditors when you're in bankruptcy, because somebody files bankruptcy if they have any assets, and once the bankruptcy estate is settled, the secured creditors are going to be paid off first. And so it is important for people to be sure that they get a security interest on whatever debt that they may have. And so our book talks about the Uniform Commercial Code, Article 9, that provides an avenue for securing an interest, and it talks about how you want to perfect your interest in that particular debt. And so to do that, it's going to require some type of collateral, maybe personal property or real property, but usually to secure that debt, somebody's going to want to collateralize it with some type of property or something that's going to be security for that particular debt. And then these are just some ways of perfecting, but this is going to be state by state, and it's going to be based on a statute or some other type of code provided for in state law that will provide the way to perfect. Although the Uniform Commercial Code does, each state has its own adoption of that UCC, and so we want to follow that. And again, common law is going to come into play. Some type of a court is going to interpret that particular statute to determine whether or not that person has perfected that interest. And then the book talks about other ways to collateralize, and that's with real estate through a mortgage, which we know a lot about. I'm sure a lot of you have mortgages. That the person who loaned you the money for that house, that debt is secured by that real property. That real property is the security, the collateral for that loan. If you were to go into some type of bankruptcy court, that particular creditor is going to come first. When it just depends on how things stack up. But then your book talks about Chapter 7, Chapter 11, and Chapter 13, bankruptcy. These are the different forms of bankruptcy. And then when a person files a bankruptcy, this is the protection that they get. It is an automatic stay. Yes, sir.
I just had a question about that, like priority in terms of people
Yes.
collecting
Uh-huh.
on your property or whatever.
Yes.
And I was trying to think of like a real world example. Like our company changed banks recently, and the new bank gave us like they were kind of complaining about how they weren't like at first in like a list that they sent us where there was like a couple of other banks, like our previous bank and whatnot, and we needed to like get a form and sign up from our previous bank. Is that what that's about? Is that
Yes,
like
it
kind of
is.
transferring over
Yes,
the-
yes,
who
yes.
Take the first money?
Yes, and so I'm not going to ask you, but I'd like to know how that worked out, because once a bank is in priority, they're not going to sign something to say, hey, unless they're paid off.
Sure.
Now, so if that loan that we're going to be getting with the new bank is going to pay off some portion of the other, then they may say, okay, in that case, but I can't see them changing their status in the line of perfection. So,
That's what that's called, the line of perfection?
well, that's kind of what I'm calling it, but it's, yeah. I mean, as in the line, of being in the list of being secured creditors. Yeah, because they take priority. They're a priority. Yes, sir. Yes, ma'am.
If I have $5,000, I file for bankruptcy. I'm about to foreclose on a home or something, and I owe the bank $132,000.
Wait a minute. Hold on. Okay, you do what now? Okay, I got started.
I owe the bank $132,000.
Uh-huh.
I got about $5,000 in assets. I'm filing for bankruptcy.
Uh-huh.
Do they get a portion of that if they're first? Like, let's say they have priority because they're a secure loan or whatever. Do they get a portion of that, or do they take the whole $5,000 and nobody else gets anything?
Well, it just depends on what type of bankruptcy it is. One of this chapter 13, it puts you in a position where you can now, the bankruptcy trustee can tell, can find out what you actually have, and then you go into a payment plan with these different debtors. Okay, with this chapter 7. I mean, it just depends on. At some point, the house may have to go back to the person that it belongs to, which would be the bank at that point. And so they'll get their house, which is the collateral. Yeah.
Will they get the $5,000 in the house?
Well, they wouldn't really. It just depends. Yeah, it really does depend, because it just depends on who else is in line. I mean, I'm sure they were probably first somewhere, but if you got IRS debt, if there is student loan debt, so then the bankruptcy trustee kind of figures all of that out, or some of that will, and then the judge will discharge some of that debt, but he's not going to discharge debt on the house. You know what I'm saying? Yeah, because that has been perfected. With the collateral, which is the house. So that was the agreement.
Oh, I get what you're saying. When
Yeah.
you get a mortgage, what
Yeah.
you put up for your collateral is the house
Right.
that you're getting the loan for.
Right. Okay, so you're going into bankruptcy, and so now at some point now an automatic stay goes into play, so they're not going to kick you out right then and there. See, that's the protection of the automatic stay. That tells everybody, stop calling, stop doing whatever you're doing. Let's let the bankruptcy judge, the trustee, figure this out first. All the creditors, there's a creditors meeting, and all these things kind of happen. Everybody comes and try to figure out who's where, how much you have. That's what this whole thing is all about. But and the bank may work something out with you at that point regarding the house. This is where all of that takes place. But it's not going to last forever. At some point they cannot. At some point they need to be able to get their collateral. And then we talked about the bankruptcy trustee. And then there's the voluntary, which is when we just go to the court and file bankruptcy. And there are some cases where debtors may get together, a group of debtors may get together and file bankruptcy, and it would be called an involuntary bankruptcy against the debtor. And then for people who just like to file bankruptcy all the time, there are protections in the bankruptcy code. They do a means test to determine whether or not you really do need to be filing a bankruptcy. You have to do proof of income. There are some in credit counseling. There are some, because at some point people used to just file bankruptcy whenever the debtors start calling. I mean, the creditors start calling. And so to put a stop to that, they put in protections in the bankruptcy code to.
So what about people like Trump, who's filed bankruptcy multiple times?
I know
Is that like after that?
Okay, so let's clear up the. If you let Trump tell it, he has never personally filed bankruptcy.
Oh, his corporations filed bankruptcy.
Right.
But so there's no protection against corporations then.
Well, I mean, I'm just saying you can really file. I mean, nobody can stop you from filing a bankruptcy, but I'm just saying once you file it, at that point they do means testing and all these kinds of things to determine whether or not it's a valid bankruptcy or not. If it is, the court will dismiss it. So, I don't know what happened in those cases, but the Trump companies have filed bankruptcy. Let's just gotta keep facts. So anyway, so here is your order of priority. Here is your order of priority. Mr. Colbert, here is your order of priority. And there's a nice little chart in your book that talks about how this all works out: administrative expenses, involuntary bankruptcy expenses, unpaid wages, unsecured claims, claims by farmers or fishermen. There's this list of order of priority for unsecured creditors. And then here is a listing of property that is exempt. So, you know, these are things that, you know, you can keep your jewelry up to $1,600. After that, it becomes a portion of the bankruptcy estate.
Is that why people lie about the cost of their jewelry?
But you can find out. I mean,
$20,000 mother of pearl.
yeah, they can say that. Yes.
It came from a dive store.
Well, yeah.
$5.
Well, yeah, you can say that, but then the bankruptcy trustee is there, and if push comes to shove, they will do an evaluation of the value of the property. Yeah. And then claims for federal, state, and local taxes. These are things that within 2 years of filing, these are things that will be non-dischargeable. So things that can be discharged, but these are things that you cannot discharge in a bankruptcy. Alimony. Don't go to the bankruptcy court trying to discharge alimony. Child support. It's not going to happen. Debts related to willful or malicious injury to person or property. So let's talk today about Happy Feet. Happy Feet. Happy Feet Daycare.
I remember that.
You do?
I do.
How do you remember this?
I remember hearing something about a Happy Feet daycare
Really?
in the news. Yes.
Okay. But, okay.
But it was. I don't think it was for like a bankruptcy. It was for what is negligence.
Okay. Okay, so let's look at it then. Okay, let's just see Who can I find to volunteer to be the owner of Happy Feet?
Is that the owner of Liability?
No, that's the mother whose baby. Do you? So I got to tell you all the facts before you decide whether you.
I don't think anybody's gonna want to be that day.
Come on!
Are you kidding me?
Come on, somebody.
Death of an infant? Yeah, no. I'll probably
Yes,
do that.
Mr. Happy Feet. Thank you.
Oh.
Thank
Give him
you.
5 points. He ain't making this out alive.
Thank you, Mr. Happy Feet. So let me tell y'all about Happy Feet. Now, I already, I just want to let you know before you start, because you know how you get all upset with the cases. Now, you're gonna get upset with you. This is not gonna make you happy. Okay, I'm just letting you know. I'm letting you know already. You're not gonna be happy about this.
It says right there, wrongful death lawsuit.
Yeah, you don't like it. You don't like
Involves
it.
the death of a child. Yeah,
I know you're not
happy.
gonna. Even though this is Happy Feet daycare,
No.
you're not gonna be happy.
Uh-uh.
It was a wrongful death against a health insurance company. It was like $9 or $10 million. Big bucks to get wrongful death.
Yes, but this one is 1 million. Let me see. I'm gonna go through the. Okay, I didn't open up enough documents. Okay, let me open up the. Okay, so I'm gonna go ahead and open up the bankruptcy docket sheet. Okay, well, no, let me. Yeah, I'm gonna go ahead and do it. Well, it's the organization of how this happened. No, that's not gonna work for me to do that. I'm gonna go here. Okay, so let's just go through some of these facts first, okay? So during 14-month-old, they're calling them BB's, second day at Happy Feet Daycare, he was found asphyxiated during nap time. BB's parents, these are the creditors, Shiloh and Joshua. They're the creditors and they're going to be calling them the creditors because now we're in the bankruptcy court. So you're going to see them call that. Later filed a state court action against Gloria Galan, the debtor, who was the owner and the operator of Happy Feet, and were awarded $1.267 million in damages in a default judgment. So the state court case was filed, and they didn't even feel the need to answer. And so a default judgment was entered. When the debtor so they knew they were going to file bankruptcy, I guess. So once the judgment came down, then the debtor subsequently filed Chapter 7 bankruptcy. Okay? So the creditors, so once they filed the bankruptcy, so I was trying to show you the bankruptcy docket sheet. You can see the bankruptcy docket sheet. Once they did that, then the creditor said, no, we have our judgment. So they filed what we called an adversary proceeding to object to the discharge of this debt in bankruptcy. So the parents who have the $1.26 million judgment, they're now filing what we call an adversary complaint in the bankruptcy court. They're saying, no, judge, please do not discharge this judgment debt. And so now that's what the court is going to consider. That's what the court is considering in this particular opinion. And so the creditors commence this adversary proceeding seeking a determination that the state court debt is accepted from discharge in the debtor's bankruptcy case under this bankruptcy code, because it resulted from, here are our buzzwords: willful and malicious injury. So remember that slide I was showing you of debt that's not discharged in bankruptcy. This is the legal theory that they're using here to ask the court, the bankruptcy court, not to discharge that debt. So what we want to look at is I'm gonna go straight to it. So what you do is we're in Idaho, okay? And so I guess their thinking is the first thing you want to do is make sure that Happy Feet is not incorporated. If Happy Feet is incorporated, can they sue Ms. Galan personally? No. But they sued Ms. Galan personally, so what does that tell you? It's not incorporated. So the way they do that, they go right here. Here's the Idaho Secretary of State, and I'm going to put in Happy Feet. Okay, look at all of these Happy Feet. Mr. Happy Feet. I'm looking for you. Which one? Okay. So now look at this. It's very specific now. I want you to look at it. Okay. So look at the name of this. Happy Feet Daycare. I got Happy Feet. I got Happy Feet. I got Happy Feet Child Care. I got Happy Feet Daycare, all one word. When I go and look at these two, they're not Happy Feet. They're not you, Mr. Happy Feet.
Is that my last name?
But you, huh? Huh?
Is that my last name?
For today, you're Mr. Happy Feet. You took on the role of Happy Feet.
I mean, like, is that the real person's last name?
No, that's not their real name. Their name is Miss Galan. Remember Gloria Galan. So look at this. This is Happy. See, is that Gloria?
No.
That's not Gloria.
What is with the name Happy Feet? But I don't get it.
Huh?
What's with the
They
name
were
Happy
trying to
Feet?
capitalize on the movie when it came out, I'm sure.
I don't know what's with the name Happy Feet, but after this case, I would not name my daycare Happy Feet. It would not be Happy Feet, Mr. Happy Feet. Okay. He's tired. He's already tired of being Happy Feet. No, just stick with it for a little while longer. So Happy Feet is not incorporated. So they go and they sue her personally. She is holding all of the personal liability personally by not incorporating that business. When you go out and you want to have a daycare, I guess in a state like this, we'll learn that you don't have to have insurance. You don't even have to have insurance to have a daycare in this state. I knew you would go. I just said that just for you. Yes, ma'am.
So, did she file for bankruptcy, or did her?
So, because they sued her,
Yeah.
she filed for bankruptcy.
So she
Personally.
herself. Okay,
Yes.
okay.
No,
Not
her business
company.
can't file for bankruptcy, can it? Because it's not incorporated, so it's not its own entity.
Yeah.
Well,
So wouldn't it be like one and the same?
yeah, it would be one and the same. Yes, it would be one and the same. Because she has not created a alter ego person, the corporation. She has not created that. She has not filed her articles of incorporation. So
That
she
is her.
She is Happy Feet.
Yeah.
You are Happy Feet. Okay? Happy Feet. We coming straight to your house. Whatever you got, hide your money because we coming straight for you. Okay. You have no protection because you did not incorporate Happy Feet. Yes, sir.
So,
Why would you choose to make a corporation and not file your corporation papers versus doing like a sole proprietorship?
Okay, so wait a minute, well, so we don't have a
She's
corporation.
not actually a corporation.
Right. We just happy feet,
So is
not
she-
incorporated.
Is she a sole proprietor in this case?
Then I guess you could call her sole proprietor. I mean, you guess. Yeah. And this what happens to a sole proprietor. This is what we
When they're
learned.
negligent.
Did we learn in class, does a sole proprietor have any protection? We learned in class, in our last class, they do not. She must have got right up. Yes, thank you. No protection. So they sued her personally. Just give me a minute. You gonna pass out?
I might.
Okay, just hold on.
I'll start getting naked in a second.
Just give me a minute.
Much better, I promise.
We'll all have happy feet running out of here. Okay, so after conducting the trial on this action on July 7th and 8th, so they had a trial, 2-day trial in this adversary. And they offered evidence, testimony, and legal arguments, this memorandum. You know, usually, and he was real good about putting, but I wish he would have said right here what he was gonna do, but he didn't say it right there, so. But you're not gonna like it. I'm just letting you know. Okay, so along the way, the debtor obtained multiple child care and safety certifications. Debtor opened Happy Feet Daycare. See, she just opened it. There's no ink. It's not Happy Feet Daycare Incorporated. It's just Happy Feet Daycare. Okay.
It's like a lot home kind of thing.
Yeah.
Right? Okay.
Yeah, yeah. She opened and provided care for up to 6 children at the time. And in February 2008, she secured a daycare permit. It's strange how she could get a permit. She had no insurance, but anyway, she got a permit, and so she could care for more children, 12 children, and she did that. Okay, so debtor was Happy Feet's only full-time employee, but she has some helpers.
Okay, yeah. She has to have another person if it's more than a certain amount of kids
Oh, okay.
legally, yeah.
Oh, really?
Yeah.
6.
Yeah, it's like 6 per
It's
person.
6 per person.
And then she has
So
to hire
legally
somebody
has
else.
to have help.
Uh-huh.
Yeah, that's like
Okay.
rules and stuff.
Yeah,
when
yeah.
you, like,
Okay.
are
Our
daycare
rules.
person.
But I was like,
Yeah.
where does this
People come
Happy
and
Feet
check
at?
it.
This is in Idaho.
Oh, yeah,
Yeah.
so they're completely different.
So these are different, so we don't know. But look, so she has, I'm just telling you, unpaid helpers assisted her in caring for the children. Among those were her son and his girlfriend.
I was just about to
Oh,
say,
okay,
so they can be
yeah.
anybody.
Yeah,
man.
family. 12-year-old,
Her
13-year-old.
son
Yeah.
and his girlfriend.
They're unpaid.
Neither of them had any training or experience in childcare. Despite not being paid, both of these individuals indicated that Happy Feet Daycare was their place of employment when they filled out the police statements. But they were not, she did not pay them. You always,
That's called being
you always
volunteering.
nitpick on the details, the infant child. Okay, within the house, particularly at nap time, debtor used different rooms to separate the older children from the younger children, who would frequently whine and cry from the younger children who would sleep. So obviously she wants to put them in separate rooms. All the young children were laid in individual playpens at nap time. In addition to playpens, this is strange what she did, but in addition to playpens, Happy Feet frequently placed the children in booster-type car seats.
Yeah, I don't think so.
Oh.
Yeah, I don't think
Okay,
so.
just calm down. Just let me just get through, okay? Okay, all right. The booster seats were manufactured with the 5-point harness and were
Carrier ones. Flathead syndrome.
So she was like
all
strapping
these children in helmets.
Oh.
Those are expensive.
Oh, man.
like an insane asylum. Yeah, she might as well get straight connected.
Y'all are gonna run me out of here. Okay, hold on. Okay, just let me get through.
I'm sorry, is that woman still alive? Because I have a feeling
Yeah, I
that.
would have killed her.
Yeah, thank you. Yeah. I would have gone to jail.
Yeah.
You kill my kid, you're dead. You do this to other kids, you're dead.
Okay. When used in a vehicle, the seat's 5-point harness must be used on children between 20 and 30 pounds and on those whose shoulders are below the highest possible shoulder harness seating. How they're typically use the seats is unknown, though it was not for vehicular transportation. The seats instruction manual is written from the perspective that they will be used in a motor vehicle. Their primary purpose is to protect children in case of a motor vehicle accident, and the safety guidelines appear to be written with that specific goal in mind. It is unclear what effect alterations to the design or use of the seats in a non-vehicular setting may have on the seat safety. However, Happy Feet did not use the seats for vehicular travel. The debtor therefore modified the seat's harnesses from the 5-point to a 3-point safety system.
It's like cut the tops off, basically. The little clippers, they just cut those off. Now it's a.
You are killing me. Okay.
Jesus.
The relative safety of using the seats outside of the vehicle and with only a 3-point harness system to secure an occupant is unclear. The court is just being clear. We're not clear about that. We don't have any expert testimony on that. The only warning relevant to this proceeding appears to be one advising the user to never leave a child unattended.
Which would be like in a car. That's probably what.
Well,
That's probably what it means. But
yeah, but
Well,
it
it
will
will
be
be strapped them into a harness and then walk into the next
Yeah.
room, start
Yeah.
eating a sandwich,
Yeah.
taking a
Right.
nap.
They're saying
Lock them in so they can't.
Yeah, exactly.
Jesus.
That's what she was effectively
no.
doing. is
It
making
says
it
never leave a child unattended.
Oh.
yeah. Well, that's just
Whether it's
yeah.
yeah, it would, but you can.
So the debtor admitted to never reading the manual.
Oh my
That
God.
was stupid. I'm sorry, forgive me.
Okay, thank
Just
you.
something you don't do.
Yeah,
One of them
she-
lock a kid.
Well, that's the only thing she admitted to.
Excuse me,
'Cause she
3-point
did- she did not admit to a lot.
there.
Okay, and so the information submitted on evidence surrounding the July 3rd, 2009 incident is somewhat muddled. Since that time, the adults involved have refused to talk to others about the relevant events, often invoking their Fifth Amendment privilege against self-incrimination. That's why they did not answer to the state court proceeding. For some reason, somebody advised them, I guess, that they could be liable, that they.
Right, for more.
Probably somebody
For
took-
some
Somebody
criminal.
out of jail.
Like,
Excuse
Yeah,
me.
but I think every parent would sue if they found out other.
Well, not
human
just
beings
sue, not just sue, but look, when you assert a Fifth Amendment privilege against self-incrimination, that's criminal charges. So, I don't know.
Right, because it was asphyxiation, however you say it. Yeah.
So isn't that murder?
No.
Why?
But-
Manslaughter.
Okay.
depends on the circumstances.
Thank you for speaking up on that, Mr. Happy. You have
I would say a 15-month-old
He's like,
child.
he's protecting himself.
you answered real quick, didn't you?
I don't know, I'd say 15-month-old dying of asphyxiation and by, general location.
Okay, so hold on, just let me get all. Okay, just let me get all the facts. Okay. The week before the incident, creditors visited Happy Feet and they discussed the safety of the place. Upon conclusion of that visit, the debtor and the creditors agreed that Happy Feet would begin caring for their children. Okay, so they had all three of their children, including this infant there. And so July 3rd, 2009 so the first day was fine. The second day, July 3rd, 2009 was BB's second day at Happy Feet. Present that day were the debtor and the two adult helpers that she had, her son and his girlfriend, as well as several other children. BB arrived at Happy Feet sometime between 10 and 10:30 in the morning and began to fuss and cry almost immediately. He cried incessantly most of the morning.
Probably because he was in a freaking car seat the whole day.
Well, hold on, we don't have those facts yet. He just got there.
Oh, he's got flat head now. He's all messed up.
Hi. Debtor attempted to pacify BB by holding him, rocking him, laying with him, giving him a bottle, and placing him in a playpen, none of which worked. The responsible adults at Happy Feet attempted to feed BB his lunch, but he would not eat it. Instead, threw his food on the floor. Eventually, the only treatment found to moderately placate him was to place him in one of Happy Feet's booster seats. I'm not very good with it. Seeing that Gonzalez fastened BB into a booster seat, then seeing that she fastened him into a booster seat, you're not gonna like this, then lifted and placed the booster seat into one of the playpens in a small bedroom.
Oh, yeah. Mhm.
She did not secure the booster seat to the playpen in any manner.
I wonder how this kid officiated. I wonder, is it weird?
Debtor
Never
was at
mind.
least
Go figure.
the debtor, who is the unincorporated owner, Mr. Happy Feet, was at least present when the decision to do so was made.
Oh.
Even though she didn't tell her to do it, she was present when
Does this woman
the
have
decision
kids
was
of her
made.
own?
The
Once,
son, yeah, he's alive for now.
once,
He's an adult
Gonza-
son.
Oh, yeah.
Once-
Yeah.
How he
once-
survived.
once Gonzalez placed the seat in the playpen, which occurred sometime between 1:30 and 2, the responsible adults all left him in the room to cry unattended.
Oh, my word.
After a short time, BB's crying abated. And at about that time, debtor left to go to the bank.
Oh, Lord,
Oh,
I can't believe it.
God.
Oh, my God.
Has anyone seen a 1-year-old throw a tantrum? They move. They don't just lay there.
Debtor's July 3rd, 2009 written statement indicates that BB quieted down around 2 p.m. One other fussy child had been left in the room with BB around 2:10, so Gonzalez entered the room to get a diaper for that child. Upon entering the room, she saw BB slumped over in his seat. She tried to wake him and turned on the light. Seeing that BB's lips were blue, Gonzalez removed him from the car seat, placed him on the couch, and screamed for the boyfriend, who immediately called 911.
And of course, none of these people know how to give mouth-to-mouth to
Right.
a baby.
Yeah, because
they're-
remember in the
They have
beginning,
no,
they
Yeah,
had
they
no
didn't
training.
need CPR and training
No.
for patients.
So, at any rate, the child, they were able to resuscitate the child, but he died at some point later. And so,
Because he was asphyxiated.
here's some more facts before we get down to the meat and bones. The police contacted the Child Advocacy Center, the Idaho Department of Transportation, and the American Academy of Pediatrics, none of which have studied or heard of other out-of-vehicle car booster seat deaths. I wonder why.
Yeah.
Use it.
Shortly after BB's death, creditors sued the debtor in state court. Debtor did not respond to creditors' complaint, and the default judgment was entered on November 16, 2009. The judgment was amended on January 5th, 2010, and creditors were awarded damages in the amount of $1.26 million plus interest. Without debtor providing any evidence to the contrary, the state court judgment accepted creditors' allegations concerning the debtors. Based upon the allegations, the state court found debtor's conduct, at least as it was pled, to be reckless. Okay? Debtor filed Chapter 7 bankruptcy petition in January 7, 2010. The creditors commenced this adversary action seeking to accept the court judgment from the discharge. While the debtor was called as a witness to testify at trial, she asserted her Fifth Amendment privilege against self-incrimination in declining to answer most of the creditors' attorney's substantive questions. And so the court goes through its analysis, and in the end, it finds that this is not a case where the creditors have been able to prove beyond a preponderance of evidence, which is the standard in the civil bankruptcy court, that the debtor acted willfully or maliciously. This was an accident.
Mother is hard. Right, yeah.
So it's negligent,
Yeah.
right, but it's not, right.
And her actions may have been reckless, but when you're talking about murder, that's a different standard. It's like intent. Like somebody willfully did something. We all agree that she was not willful. Yes, ma'am.
So what would have happened if they had have gotten charged with a crime that was serious, such as manslaughter or something like that? Would it have?
I don't know if
been,
manslaughter
like,
would do it, because what we when you start to, if you start to do more law classes and you start getting more into law, you will understand that when it comes to these types of things in the civil and in the criminal context, there is what we call a requisite culpable mental state. And so it's there, and one of them is intentional, one of them is reckless, one of them is negligent. If you need intent here, willful, malicious, that's where you get to the intentional requisite culpable mental state. And even if they were charged with manslaughter, the requisite culpable mental state for manslaughter is just more so somebody acting in a negligent or reckless way,
So it's
but
not the
it's
same.
not
You don't think she acted
intent.
in a
We never easily
negligent,
prove it.
reckless
It's
way?
saying it's the same thing though. It's the same as saying that it was reckless in the bankruptcy court thing. It's the same as manslaughter being reckless. So it's essentially you still have the same argument.
Even though she went to the bank, it's still not.
But the first
Willful.
thing you do is when a child quiets down, you check on them.
You could probably get on man 3, but
Just
that's
to make
probation
sure they're
first
okay,
offense.
it's
So.
what you do.
If
Because
they're-
the child goes for being
Well,
upset
no,
for 3.5
because
hours.
think about it. She put the
and then-
child in there to quiet. She says that she put the child in there to placate for the child.
Yeah,
But
right.
right. She
You
put
wanna
him in
do-
there to lock him in the room by himself where you
No,
cry when she wouldn't be able to hear.
I'm asking you,
Otherwise,
do you
you
want
lock
to?
him in a booster seat,
Okay.
put the
Right,
booster seat,
exactly.
and then leave.
And that's not willful? You know, that's not willful? I'm sorry.
We're gonna do one or two Socrates questions, just to see just how much you feel about
You have
this
to
case.
spend that. It is, you can't leave a child in a car seat because it can give them brain damage. So,
Yeah,
yeah, period.
yeah.
So that's what I would have fought for, is somebody to come up and, some expert to come up and say that, because.
Well, yeah, you figure this family has 3 kids, they would have read
Yeah,
that.
obviously.
I have 1 and Ralph Ivory is. Well, I'm the only one who's close.
Ooh, y'all gave me the blues today, boy. I'm telling you right now. This is why I feel like I'm beat up. Okay. Would you have advised the owners of Happy Feet to register the business as a corporation to avoid being sued in their personal capacity, keeping in mind, yes, she filed bankruptcy, but now that bankruptcy is going to go on her personal credit record. That's going to go on your personal credit record if you do this business as sole proprietorship, something like this happens, and you have to file bankruptcy. Okay? So, in keeping all that in mind, would you have advised these owners to incorporate this business, Mr. Happy Feet? We're going to give you some advice, okay? It's too late?
True.
Oh, yes. Incorporate the business. Okay, well, let me see this. Let me see how y'all feel about this one. Hold on. Let me see how you feel about this one. Hold on. Do you agree with the bankruptcy judge's decision to determine that the debt the owners of Happy Feet incurred from the state court judgment was in fact discharged in bankruptcy? Do you agree with his decision to determine that that bankruptcy debt was dischargeable?
Is this from a purely unbiased, like, if I was a judge and I have a decision to make that, you know?
Do I have to follow the law is what she's asking.
Yeah, like, you know, like, are you asking me as a person or are you asking me as, like, I'm the
The
judge in
law,
that position and I have
no,
to
the law
decide?
says it has to be willful or malicious.
Okay, so.
Okay, so let's use the law. How about that?
Oh, too late.
Mr. Happy Feet, let's see what they're gonna do for you this time, Mr. Happy Feet. Let's see if you have any friends in here.
Go.
Ah,
50 about. Oh,
no, they want to send you down in the gasoline can.
Can't win them all.
Okay, all right. Just remember that the activity that we'll be having will not. If this classroom is open, you can come in here and do your activity, but the activity will not take place.
Got it.
Okay.
But,
In-
quick
in
question.
the-
Are we gonna be here?
You have worked
I
for
got
the day.
She's
Yes,
on a roll
sir.
tonight.
I came in late. What activity?
See me after class. Was that a joke?
No.
See me after class, then. Okay, see me after class. See me after class.